recognition that regulations as opposed to statutes have come to dominate how our administrative state regulates health, safety, or environmental risks. So instead of trying to defend that point myself, I'm going to do something I encourage my students not to do, which is make a naked appeal to authority. So one scholar says, quote unquote, regulations issued by administrative agencies have eclipsed statutes as sources of law. That's of course Kevin Stack writing in the Michigan Law Review. And I think that's right. So the way that cost-benefit analysis works in practice is administrative agencies, for most regulations, not as a matter of statute, but a matter of complying with executive orders that have been in place since 1981, conduct a cost-benefit analysis in their agency, and then they send it out to this executive branch office called OIRA, the Office of Information and Regulatory Affairs, which checks their cost-benefit analysis, pushes back in some point, and together comes up with the final rule. So under existing law, every rule which has a significant impact on the economy, which is effective $100 million or more, goes through a cost-benefit analysis. So most of the federal regulations that affect you, and certainly most of the significant regulations in the environmental area, go through cost-benefit analysis. That's why I think it's so important and why it interests me. So what I want to do in this talk is describe the problem, briefly outline my solution, and then gesture at some of the indirect effects that I hope my solution will have. So I'm going to give you the 90-second version of the intellectual history of cost-benefit analysis. So in the 70s, 80s, and even into the 90s, there was a robust academic debate about whether cost-benefit analysis was even justified. And then there are still leading scholars today that think cost-benefit analysis is illegitimate in principle, that we should never weigh human lives against economic costs, as some of the scholars would put it. But I think thanks to the efforts of many defenders of cost-benefit analysis, and the most prominent among them is probably seated next to me here on the panel, Professor Viscusi. Cost-benefit analysis proponents, I think, have carried the day. And the main argument that really has persuaded even people who are skeptical in principle of cost-benefit analysis to come on board is an argument closely associated with Professor Viscusi. This argument about risk-risk trade-offs. That is, there are certain types of policy issues where both a government regulation and the absence of a government regulation would have environmental effects. So to take a very stylized example, think of nuclear power, right? Now, nuclear power has all sorts of environmental risks associated with it, but it also has potential environmental benefits. I mean, I think anyone in the environmental world would tell you if we were to replace all of America's coal plants overnight with nuclear power plants, we'd probably have dramatically less carbon emissions in our society. So that's just one type of example of this risk-risk trade-off argument that is pushed a lot of people who are maybe skeptical of cost-benefit analysis to accept the idea that we need to do some sort of weighing of benefits and costs in government. That was the first generation debate. So then there's a second generation debate where everyone said, all right, if the government is going to engage in cost-benefit analysis, let's make sure the substance of those decisions is right. So questions in that debate revolved around, how do we think about future generations? How should their welfare count? How should children be counted versus adults? How should non-citizens, people outside the United States, be counted in these welfare calculations? And then more specifically, critics, particularly on the left, are starting to ask, are the agencies doing a good job of anticipating how industry will respond to regulations? Will they respond in a way that actually adapts to regulation and imposes fewer costs than were initially imagined? Or are there sometimes unanticipated costs of regulation that aren't being considered in the initial cost-benefit analysis? That was the second generation debate, and I think it's been very fruitful, but I think that has largely come to an end. My hope in this paper is to bring out a third generation debate. And the problem that I'm interested in is the institutional structure of cost-benefit analysis. So specifically, my criticism is this. I criticize what I call snapshot cost-benefit analysis. And by that I mean, when cost-benefit analysis decisions are made, is at the point in time when we're the most ignorant about actual costs and benefits. If you think about it for a while, it sounds kind of perverse, right? we're making estimates and guesses about how firms are going to react to new regulations, about the type of effect they're going to have on the environment, when we have to go purely on speculation and educated guesses drawn by loose analogy from other regulatory contexts. So predictably, initial cost-benefit analyses are often inaccurate and are often off by wide margins. So my view is that agencies should move to a more iterative process where they start off with one cost-benefit analysis to promulgate a rule, but they also anticipate adopting in the future a more stringent rule. And if an outside party later comes to the agency and shows that this more stringent rule has now become cost-benefit justified, the agency should adopt that rule. So essentially, I'm proposing a triggering mechanism, a way of self-updating rules. I want to be clear, I'm walking a tightrope here with this trigger, right? Because if it's too automatic, that is, if rules are automatically become more stringent without further analysis, then we might trap ourselves into promulgating and anticipating rules that aren't cost-benefit analysis justified. We always want to be able to make sure that our anticipated rules, it turns out, were cost-benefit justified when we put them into the action. But on the other hand, I think it does need to be somewhat automatic. And here's why. In 2011, when Cass Sunstein was the head of OIRA, the administration adopted what's called retrospective analysis, which means for the first time the federal government is looking back at its old rules and seeing if the costs and benefits have been borne out by practice. But the problem right now is that most agencies are doing these look-backs, but then not revising their rules. So they're generating a lot of useful information, but they haven't been changing them. And most importantly, they haven't sent a signal to outside actors to let them know that there's a likelihood that they're going to be updating rules in the future. So that's the last thing I want to talk about, now that I've described the problem and the solution, the indirect effects of my plan. So what I'm hoping will happen is if agencies pre-commit to a more stringent rule than the rule that they're enacting, when that rule becomes cost-benefit justified, that future promise sends a signal to the private sector, to firms, to develop technologies that will bring that more stringent rule about. So for example, to take a really stylized example, which is factually inaccurate, fuel efficiency standards. If you can imagine an administrative agency committing to, you have to get your median vehicle to 25 miles per gallon, and then pre-committing to 35 miles per gallon in the future. If you're that car company that figures out a way to reduce emissions in a more efficient way than your competitors, you have this incredible financial incentive to trigger this new regulation. And that incentive gives you the financial interest in investing in new technology. So my hope is that this type of proposal will spur investments in risk-reducing technologies. I also hope it will generate more of a test of the credibility of predictions. So right now in cost-benefit analyses, industry will make predictions about expected benefits and costs, environmental groups will make predictions, academics will make predictions, but because there isn't a moment where agencies look again at those initial predictions, we don't quite have the track record that we should have about learning whether the predictors are credible. I hope that if we have an iterative process, it's possible that firms will decide we don't want to take the most aggressive position on these estimates now because we're going to be held accountable for whether our estimates were right in the future. And the final indirect effect that I think is interesting is about priority setting. So this paper has a lot of complicated math in it. Not complicated in the sense that it's difficult. I mean, it's like 6th grade level math. But I know for lawyers, at least for myself, like anything that has numbers in it immediately makes my eyes roll over. So I've given on the handout a sense of how the math would work. The critical innovation that I'm proposing is what I call the difference in expected benefits. That is, agencies should be setting their rules based on a consistent figure across every rule an agency administers and across all agencies for the amount in dollars of benefits that the new rule is supposed to produce. What this is envisioning is an implicit priority setting mechanism. That is, if every agency is updating rules when a certain amount of dollar threshold is met for the improvement, administrations will be allocating their rule updating authority in a way that's not dependent on politics and not dependent on which agency has more clout with the executive branch, but on what rules can be updated to generate the most net benefits for society. So it's an ambitious proposal. It is a proposal that will require agencies to rethink how they do cost-benefit analysis and require scholars, I think, to rethink how cost-benefit analysis would be used. I think there are a lot of practical obstacles to make this happen, and I'm happy to talk about them with you today here. Thanks.
I appreciate the introduction, which is show that if you hang around lawyers long enough, people think you're a lawyer. Although I was a professor at Harvard Law School for 10 years, 10 and a half years, I've been a professor here for 10, this is my 10th year here. I've never taken a course in a law school. I don't have a JD. But I do like lawyers a lot. So.
It's a small club, right?
I also tend to like benefit cost analysis a lot, since I'm the past president of the Society for Benefit Cost Analysis. As you might guess, I'm going to be in favor of benefit cost analysis. I think this paper raises an interesting issue. It calls it cost-benefit analysis as a commitment device. And it focuses on how to set regulations when there's changing information about benefits and costs. So what he wants is an automatic procedure where we learn that there's a rationale for more benefits than we thought before. Automatically, the regulation becomes more stringent. So the paper he has is completely asymmetric in terms of its focus. So it focuses on strengthening over time, but it also could be the loosening regulations over time as often. So there's no trigger in his proposal. There's no trigger for relaxing regulation. The only trigger is for tightening regulation. I also think the title of the paper is sort of wrong. It's not really. It sounds much more upbeat than it really is. Cost-benefit analysis is a commitment device. Sounds really solid and strong. Whereas really, from the standpoint of the firm, it's a randomization device. You don't know what's going to happen to the regulatory requirements in the future. It's pretty much up for grabs. I first got interested in this general topic after working in the government. And there's a paper I wrote called Frameworks for Analyzing the Effects of Risk and Environmental Regulations on Productivity. And it has lots of fancy math that even go beyond the 6th grade level. It's in the American Economic Review in 1983. And focuses on what's the effect of regulatory policies on investment decisions. And at least then, and I think even continuing today, companies worry about the high costs of risk and environmental regulations, which run into billions of dollars. And the question is, how do firms respond to changes in the regulatory structure over time? So I did one set of models. What if you know what the change in regulatory stringency is going to be in the future? Well, if it's going to get tighter in the future, you want to underinvest in the output or scale, but there's going to be no distortion in terms of your investment in risk or quality or environmental protection. If, however, there's an uncertain change in regulatory policies, if regulatory policies in the future are highly uncertain, it discourages firms' investment. It also leads to lower protective investments in health, safety, and the environment than if they had a known schedule of what's going to happen in the future. So what we have is that regulatory uncertainty not only discourages investment, but it also discourages environmental protection in situations in which firms have to make irreversible investments. There's a reason why firms love safe harbors. They like to know exactly what requirements they're going to be faced with in the future, because that facilitates making long-term investment decisions. I also have another paper, which has a title not unlike the theme of his paper, which is how do you regulate uncertain health risks? So the probability associated with the risk is uncertain when there's changing risk information. So when over time we're going to learn more about the risk, what should we be doing? And a lot depends on the nature of the irreversibility. So if you're worried about investment. They can't decrease it because it's sort of a lumpy investment. It's optimal to under-regulate initially and then tighten the regulation after the adverse information becomes available. I also have another example that I thought the climate change advocates or opponents, depending on how you label them, would be interested in. I did it in the paper then. Global warming was not a big issue back in 1984, but the depletion of the ozone layer in the atmosphere was, so it's the same type of thing. If the harm to the environment is going to be permanent and irretrievable, in situations in which there's uncertainty relative to the harm, you want to overregulate now. Just go ahead and overregulate. For those who say that we're not really sure about the linkages between climate change and human action, the policy solution, the efficient solution, is to overregulate rather than to underregulate. Let me do another example. CAFE standards. So automobile companies have to hit an average of 54.5 miles per gallon in 2025. So they're really working hard at this now, and this is not something they're going to turn around overnight. They're huge investments. NHTSA, their estimate of the cost is $177 billion. EPA estimates it $192 billion. So these are the kinds of things where you want regulatory certainty so that companies can devote the time and the investment resources to try and meet that standard. Now, there are also substantial benefits. Depending on whose analysis you use, NHTSA or EPA, the benefits are $521 to $613 billion. But almost all of these benefits, 85 to 87% of the benefits, are because we're saving fuel cost savings to consumers. But at the time they did this analysis, gasoline was like $4 a gallon. Now it's like under $2 a gallon. So if we're going to also be jerking companies around in terms of making regulations more stringent when we get the adverse risk information, by the same token, we should also be loosening the standards or changing the 54.5 mile per gallon standard every time we get new information about gasoline prices. And I oppose the sort of fluctuating regulatory standard. I'd rather see a stable regulatory standard. So my summary comments. There are multiple components to these analyses, not just the dose-response relationship. When EPA calculates the risk associated with anything, there's like 5 or 6 numbers that go into this. You have to worry about the age distribution as well, and the population distribution. Lots of things change, so it's not just one thing. So there are a lot of reasons why the analysis may change. Once it does change, you have to figure out, do you want to change the regulatory policy? Let me just close with one anecdote. Matthew mentioned the example of Cass Sunstein with his Look Back initiative. Well, he wasn't the first person to look back. The Reagan administration tried to look back as well. They did a look back with respect to the cotton dust standard. The cotton dust standard has been challenged up to the level of the U.S. Supreme Court where they lost. And then the Reagan administration said, gee, we're going to do a favor for the textile industry. We'll relax the cotton dust standard. So they commissioned OSHA to do an analysis, and I actually did the analysis for OSHA, having just been part of the Carter administration regulatory oversight staff. And sure enough, a relaxation in the standard was warranted based on the benefit cost analysis. However, the firms that already complied with the standard didn't want to change it. So there was opposition from industry to relaxing the standard. So even in situations where the industry can get a loosening of the standard, lots of times they oppose that, having already invested in the compliance costs associated with the regulation. In general, constant tinkering with regulations, whether it's tightening standards or loosening standards, is not as effective a regulatory strategy as is having a stable regulatory approach. That's it.
I'd like to reiterate my thanks to the organizers and to Matthew for coming down. I'm really pleased that that LPAR selected this article for highlighting this way. I think it's a really important article, and what I'd like to do is spend a little bit of time talking about why I think it's an important article, and then raise some practical objections, some of which overlap a little bit with what Kip Viscusi was mentioning, and some of which don't. So to speak to why I think it's an important article, I think that we turn to one of the critical problems in law is to try and figure out how legal rules can be sufficiently dynamic while at the same time providing protection for reliance-based and investment and incentives for investment-based expectations. And that's a problem that is familiar in law, as his paper suggests. Common law courts are thinking and have modes of revising and becoming dynamic, and we're familiar with the tools when they perceive enough societal or technical change that common law courts will change. Part of what we look to regulatory bodies to is to be proactive and think about adjusting. We think of them as being more nimbly able to respond to technological and other kinds of change. There's also a sort of a qualification, a problem built into that structure, which is they rely on static analysis in lots of different ways. So they rely on static analysis. Their analysis has to be static to the extent that they're going to look at the studies that are available at the time that the analysis is happening. They're going to look at, that they can be technology forcing, but they're oftentimes constrained by the technology that's available at the time the regulation's being made. And they're also making an assessment of the costs and benefits at the time of the rulemaking. And so that sort of builds in an inherently static quality, or at least a static quality to regulations. And you can it's been a long-term frustration of mine, which this paper helps to sort of answer, which is once we've made a cost-benefit assessment, and several years down the road we realize many of those costs have changed, why should we be stuck with the same regulatory regime? Now, Kip Viscusi may have some empirical information about why it's good to stick as a general matter, or kind of pre-commitment in that sense. But there's always been a frustration that the cost-benefit analysis can become obsolete or out of date pretty quickly. And I think this paper has a strategy for addressing that, and I think that's really exciting. The second problem the paper, I think, helps to address is I think there's very few, and he makes this point really well, so well that I'm going to quote from there's very few incentives in a rulemaking to provide completely accurate information. Right? So here's Matt's comment. He says, the process of rulemaking does not resemble a disinterested search for truth. Firms that would be affected by regulations, as well as proponents of the regulation, have an incentive to distort available information. So this is, and there's very few, or relatively few, or maybe not sufficient, I'll back myself, incentives for firms to really get it right. And for firms to have incentives to really get it right, you need some kind of monitoring mechanism that you could build into cost-benefit analysis. This is the second problem that I think is a really important and deep one that his paper also addresses. And I think that the solution he's offering is trying to speak to both these problems simultaneously, which is how do we have a cost-benefit assessment that can be triggered to evolve once we know the cost, and I think I would agree also the benefits have changed after, say, 5 years at a point in time. Right? At the same time, that makes the initial cost-benefit assessment a kind of prediction about, or we can think of it as a prediction that we can test. This is his argument, right, later in time. So that seems like it has a lot of attractive features, both that it allows the regulation, the stringency of the regulation to be informed by new assessments of the cost-benefit analysis, so that we get that, right, as well as provide a mechanism for monitoring. If the assessment of costs was distorted in the first instance, we will have an empirical period, I don't know, 5 years or however long the period is, to assess whether the costs and benefits are. So for those reasons, I think it's a really important, it's addressing a really important problem, and I think it's also got a really innovative solution. So what I want to close by is to ask a couple of questions in the paper that go to some of the points that Professor Viscusi was raising, and also raised some other issues. So one is, and maybe I'll start with one of the points he was raising, which is about benefits. It is one-sided. The scheme is one-sided here, which is it asks, at least as I read the paper, it asks, when can we, if we can measure that the costs of compliance are now lower, then that's gonna trigger that we can have new stringency. I think that it's important to think about the benefits side. We will also, sometimes there will be clearly measurable benefits, and we can say, are they accruing? And if the benefits aren't accruing, that I think also should be built into the pre-commitment device. this, I think, is going to raise a special and difficult issue with benefits that have a long latency period. So it's easy to think about things that happen quickly, unfortunately, like automobile accidents, right? But many kinds of risk exposures happen over a really long period of time. So it may be that we're going to have a mechanism of measuring the costs over a period of time much more fluidly than we'll be able to measure whether the benefits are accruing, especially for, say, environmental exposure where there's a long latency period. So I don't know how Matt imagines addressing those. He also, so that's one area of concern, which is the sort of one-way or two-way ratchet quality, and especially benefits with regard to a long latency period. A second point is does this make establishing an initial rule higher or lower stakes? So he makes the argument this is going to make it lower stakes because we're going to have the possibility of iterative reconsideration of the costs and benefits of the rule. I wonder, though, I think his proposal could be read as making it actually higher stakes, which is what you're doing is you're not only passing an initial rule, but you're committing to a system of triggers into the future where it actually almost kind of entrenches a set of triggers further on. And I actually think there might be maybe actually harder to get a rule passed. There's more resistance. So it could be viewed as a kind of higher stakes device, and that would then be subject to more gaming. In particular, say at the end of a presidential administration, there might be more incentives to create these kind of triggered or stepped rules, whether they're stepping up or down. Yeah, that's the prior point. And the last point I'll make, it pertains a little bit to administrative law, which is there's a worry, and I think that my sense of this worry was certainly informed by period and practice, also informed by conversations with Mike Vanderbilt, which is the more times that you have an important decision point, right? Those are times for participation, and participation is generally, we think of it as a kind of good, but it's also an opportunity for those well-resourced to put pressure on agencies. And so I wonder whether, certainly this proposal does give more bites at the apple for firms and industry over and over. And the question is going to be, on balance, are we better off overall with these additional bites going through it, additional reassessment, or in fact, could it actually be that that's going to continue to create delay and also problems in the regulatory structure by allowing more bites? So it's kind of weighing additional bites and the benefits, if you will, of this process. But overall, I thought it was a really interesting and a thought-provoking proposal. So thanks so much for coming.
Thank you.
A chance to respond.
Sure.
And you can do there or here, whatever you prefer.
Thanks very much to both Professor Viscusi and Professor Stack for their critiques. So let me address first this worry that my proposal is a one-way ratchet, because I feel like there's a sense in which it is not, and I'd like to clarify that. And then there's a sense in which it is, and I'm willing to embrace that. And let me give you an argument for embracing one-way ratchets. Okay, so here's the sense in which it's not a one-way ratchet. So when an agency does the reanalysis, when they, an outside party has triggered the rule, they've said that because of developments in science or technology, the more stringent rule has become cost-benefit justified, and the agency determines whether that's the case. The cost-benefit analysis that second time around is open to any considerations. What I've said is the initial cost-benefit analysis figures will be treated as presumptions. That is, we've looked at the costs and benefits of this rule in the past. If there isn't any new information, we're gonna rely on those assumptions. But of course, at least something has changed. That's because we're triggering new analysis. We know that by definition. However, it may be the case that something else has changed. So let's say, for example, that some firm has implemented a technology that makes cars more efficient, more fuel efficient. So there is reason to think that we have a more stringent rule. But also in the interim period, there's been some scientific evidence suggesting that emissions aren't quite as harmful as we thought they were. That sort of evidence could definitely be brought into the second cost-benefit analysis. And although I don't think it's likely, I want to leave it open to agencies to the possibility of, one, retaining their initial rule and not adopting the more stringent rule, or two, even saying, actually, what we really need is a less stringent rule. We started the second cost-benefit analysis with the thought that there would be a more stringent rule, but it turns out there have been developments that have put us in the opposite direction. So if you want mathematical examples of this is part 3 on my handout. And sort of the second scenario is the scenario where other intervening acts have made it such that the new cost-benefit analysis suggests that the rules should move in the opposite direction. So that's the sense in which I don't think the proposal is a one-way ratchet. But it is a one-way ratchet, and I embrace that in this sense, in that I want the agency to be pre-committing to rules that are in a more stringent direction consistently. So I have a few arguments for this. None of these I think is a knockdown, but I do think they're interesting. So one, and we'll see if Professor Viscusi is persuaded by this, is over time, as society becomes wealthier, as society becomes safer, the level of background risk in society goes down. And I think we can say that that's mostly been true. I think this is contested, but it's mostly been true in the past half century. One effect that this has is affecting the value of a statistical life, the monetary value that agencies assign to a statistical risk of death. So over time, the VSL has creeped up a little bit. There's no logical reason why it has to keep creeping up in the future. But if the value of a statistical life does increase over time in the future, then there's reason to think that a lot of cost-benefit analyses which incorporate the VSL should be coming tighter, assuming that we're dealing with the type of regulation where human lives are the statistical risk of loss of human life is one of the main inputs on the side urging more stringency for the rule. And my second argument is just classic, neoclassical orthodox economic theory, which is that firms have a strong market incentive to comply as cheaply as possible. So over time, firms are always going to try to find ways to comply with regulations more cheaply. So any sort of development out there that could make firms comply more cheaply, they will seek to invest in. And overall, that should make the cost of compliance lower. Now, of course, there's a response to that I want to anticipate is that if firms know that the cost of compliance is going to be held against them, reduces in the cost of compliance are going to be held against them in the next CPA, that does create a countervailing incentive to some point. But I think that incentive will usually be competed out by the incentive to just comply with regulations more cheaply. And then finally, and this is sort of the most amorphous argument, but if I'm being honest, it's the one that persuades me the most. I just have inductive reasons to think this is true. So look at lead history. That's a regulation that I start the paper off with. Over the past, it's almost 80 years now, our lead regulations, both in terms of leaded gasoline and leaded paint, have gone in a consistently more stringent direction, as we've noticed that even smaller and smaller concentrations of lead can have significant effects on human health. Now, again, I'm not making a logical claim that that's always going to be the case. For some chemicals, it could go in a different direction. But I think we've seen enough environmental risk that it has gone in the direction to think that it's an inductive matter. It's not crazy to think that regulations are going to get tightened over time. That's what I want to say on the one-way ratchet. I don't have a lot of time to address all of Professor Stack's excellent criticisms, but I just want to pull out two. For example, I think the latency period argument is totally accurate. I embrace that. I think it's very hard to apply my proposal to sort of cancer risks, something like that, where it's going to take decades to measure. Professor Stack raises this interesting point that I claim that I'm going to be lowering the stakes of cost-benefit analysis because it's going to be an iterative process. He makes the interesting criticism that actually I might be raising the stakes because I'm creating this triggering mechanism that's not going to just affect what the rule is now, but how the rule gets tighter and tighter in the future. I hope he'll grant me this distinction. I think I accept your claim that I'm increasing the stakes of the cost-benefit analysis as a whole. However, I'm decreasing the stakes of which particular rule they choose at that point in time. So my claim is this. Yeah, it's true that this one initial cost-benefit analysis is going to be very important, but it's not so important that, for example, an environmental group that wants a more stringent rule wins now. Because they might think the best strategy is to say, all right, you know what? Let industry win this hotly contested issue right now. We've got a pretty good guess in the future that cost of compliance is going to go down and the agency will adopt a more stringent rule in the future. So there might be some strategic reasons for outside actors to not fight so hard about which particular level of rule matters, as opposed to the status quo, where if that one rule is going to be in place for decades, they have to go all in. Finally, Professor Steck makes this argument that this is giving firms more bites at the apple to pressure agencies. And I think that's true, and I think that is something that's hard to avoid. But I'd say, in a way, it actually can reduce the power of firms by giving agencies across administrations, presumably of different political parties, different opportunities to fight back against agencies. So let's say at one point, in the iterative process, the agency is facing an administration that's got a strong deregulatory agenda, or it's a recession, so there's not a lot of enthusiasm for tighter regulations. Might not be able to win there. The pressure of firms might be overwhelming. But in the future, with a more favorable administration or better economic climate, it might be more possible. Now, I recognize this is an argument that can cut both ways. I'm just saying that as a response. I think it's ultimately a wash, because while firms will have more bites at the apple, agencies and environmental groups will have more bites at the apple, and it's not clear which way, which group is going to prevail. Sorry I didn't address everything, but I just wanted to hit the high notes of the excellent critiques.
Before we turn to questions, Kevin or Kip, do you have anything pressing you want to say in response?
I just have a question. This is not a comment so much as a question.
Yes.
Could you describe how the rulemaking process works in your world in terms of, is every stage that we currently have, is that going to be present, or do we cut out certain things like public comment periods and OMB reviews?
Yeah, I'm imagining that's a good and very practically important question. I'm imagining a sort of expedited notice and comment process. And the reason, for those of you who've taken administrative law, notice and comment processes are notoriously long, sometimes taking several years. My hope with making the initial CBA figures presumptions for subsequent processes is that initial CBA should vet a lot of issues, and the subsequent ones should be focused on what has changed. Hopefully it'll be narrower, and hopefully it'll be quicker. But I do think it's an important point to emphasize that we are going to be having to go through a difficult process again, which, as you mentioned, has requirements for a public hearing and the like. But it's an important trade-off, right? Because the efficiency gain of having a more expedited process trades off against the right of the public to know, and due process for industries that are going to be subjected to costly rules. So I think, unfortunately, it's an inevitable trade-off.
Great. Well, we have a few minutes for questions, and obviously if you need to leave for class, just do so, and we'll keep them here hopefully for a few more minutes to answer questions.
Similar question to Professor Viscusi, kind of more mechanically how this would work. So are you imagining, I think Professor Stack kind of alluded to this, at kind of time zero, so the initial rulemaking, would there be kind of a prospective future-looking almost scale of kind of imagining, okay, if in the future benefits go up by X number of dollars and the rule gets more stringent by X number of units? Or does this only involve kind of at some forward-looking time, 3 years out, 5 years out, that they redo the cost-benefit analysis and then kind of change the rule ad hoc depending on the results of the cost-benefit analysis?
Yeah, that's a good question. So the first part of the handout walks through the math a little bit of this. I'm imagining that agencies will pick the anticipated rule as kind of a focal point. They'll ask, following this difference in expected benefits figure that the administration will give them, what is a reasonable level of the rule that we think we might be at in the future if technology develops in a favorable way? Let's anticipate and pick that rule. And I should suggest this is not all that different from the way that agencies do CBA right now. It's often the case that CBAs will include multiple possible rules, and that there will be multiple possible levels of stringency, and there will be arguments between the parties involved in the rulemaking about which ones they want to adopt. I'm saying you pick one based on the reasonable assumptions of what direction it's going to go in, but open to the possibility that you may have just been way off, right? And you imagine that as the iterative process goes on, we're going to get better and better about guessing the direction of stringency we need to go in, right? If it's the case that within a year or two, already this new anticipated rule has become cost-benefit justified, then we might want to pick even more stringent rules in the future when we're pre-committing. But it could be the case that decades go by, there's no significant development in technology or science that matters, and we don't need to change them at all. So the anticipated rule serves as a focal point, but it's not meant to be an exhaustive set of possibilities for what the agency might do in the future.
This is somewhat related to Professor Viscusi's point about the rulemaking process in general. Have you considered the cost to other stakeholders of kind of repeating this cost-benefit analysis process, specifically if Professor Viscusi is right and the incentive is to underinvest and meet that minimum threshold rather than a higher threshold, the cost of actual ongoing monitoring to see the trend in these unanticipated circumstances, whether or not that cost is material to the other stakeholders?
Yeah, so I think part of the goal of the proposal is to create stakeholders that don't exist now who might have an incentive to monitor this. So part of what I want to change is this idea that in environmental regulation, you always have industry versus environmental groups. Now that's not always the case. For example, right now, if you're a lobbying representative for Tesla, you want those fuel efficiency standards to be as demanding as possible, right? Because your incentive is out of step with the rest of industry. In any industry, there's going to be some firm that is a little more efficient, a little safer, a little more environmentally friendly. Part of what I'm trying to do is divide and break up industry coalitions and create an incentive for someone in the industry to say, I would actually prefer a more stringent rule. I want the other firms in my industry to adopt this technology, and I'm going to encourage the regulators to go with a more stringent rule. So I do think there will be costs to firms in the industry to monitor changes in science and technology. And I do think there'll be costs to environmental groups and agencies to be doing this monitoring as well. But where I'm hoping the bulk of the monitoring and development is going on is in the firms or environmental groups that have the incentive to bring about the more stringent rule, that they will be the ones doing the investing, and they will ultimately be triggering the reanalysis. Technological advancements, and I say this as someone who's definitely not across the board free market thinker, but I do think a lot of the reason that we have technological investments in environmental protection and safety is because we create market forces. I'm hoping that this is a way that administrative regulation might co-opt market forces more effectively than they do now.
Let's take one last question, and then I know at least Kip and Matt, you can stay and for a few minutes maybe and do additional questions. JB?
So thanks, Matt, for this paper. I'm sorry I hadn't had a chance to read it, so you might cover these sort of mechanical questions. One is that you rely on a petitioning process to trigger this reanalysis. And I'm wondering what would be the standard of review? Who is the reviewer? I assume the agency would affirm or accept or deny the petition. And then we have a judicial review problem, like what's the standard there? And secondly, cost-benefit analysis is usually not the sole basis for agency regulation, right? Other public policy factors come into play. Are you anticipating that those would not come into play under this process? In other words, just the change in cost-benefit analysis would require the agency to follow through on its commitment, or the agency at this juncture could then also say, well, for these other reasons, we're not going to change our standard. In which case, we're just kind of back to where we are. I'm not sure if the commitment isn't absolutely mandatory once the cost-benefit analysis is shown to be different. The agencies can game the system by just pointing to other factors that are squishier and more public policy oriented, and they can, deflect this new cost-benefit analysis. So how do you deal with that on a judicial review basis as well?
Right, those are both very interesting questions. The first question about judicial review is I'm glad that someone's got enough admin law doctrinal nerdiness to also be interested in this. I'm imagining the credibility determination that the agency makes about triggering the reanalysis functioning something like a plausibility standard, a 12B type review. Because obviously the agency is going to conduct a full analysis if it's in fact triggered. So I'd want something with a little more threshold there, a little less fact specific. And yes, I see no reason why there shouldn't be judicial review, as there always is under the arbitrary and capricious standard. But I would say this, I'm hoping, while creating the possibility of a lot more judicial challenges, I'm actually hoping, as a matter of regulatory politics, of creating less incentive for judicial review. And the argument would be this, almost every major rulemaking now in environmental law, it seems like there's a significant judicial challenge after that from whatever side perceives that they lose. I can't get rid of that possibility because I want to preserve judicial review. But I do think if outside groups know, particularly environmental groups, if they lose at the agency, lose in the sense they don't get the rule that they would have preferred, they might think that if they're confident about their factual predictions about where the cost of compliance is going to go, then it might just make more sense to wait out for the reanalysis rather than to bring a judicial challenge, particularly because, as we all know, these judicial challenges can take years in and of themselves. So I would preserve some judicial review. I would be deferential to the agency about its decisions on the credibility determination, but I would make the standard, favorable to the party that wants to bring it, because it's really just the threshold question of getting to the analysis. So the last point you bring up, the automaticity, I think is the toughest piece of this problem, because we've got two possible ends of the spectrum. At one end of the spectrum is most regulations in the status quo, where we pass a regulation without explicit anticipation of what's going to happen in the future, and there's massive uncertainty about what's going to come out next. And then on the other hand, we have something like the CAFE standards, where, as Professor Viscusi explained, we know what the rule is going to be in the future without even an additional cost-benefit analysis. We've already committed to it. I'm somewhere in the middle, right? In that I want there to be this explicit anticipation of a rule, but I'm also open to the possibility that when the rule is reconsidered, that the agency could wind up going in a completely different direction. So let me tie this into the point you make about other considerations, because I think that's very important, especially because I'm the sort of person who doesn't think that CBA is a straightforward welfare calculation. It's just a convenient decision procedure. Sometimes we want to adopt a rule that it's hard to directly justify on quantitative grounds, because, say, for example, there's a consideration about human dignity at work in play that we think is important. So I think what an agency would do there is in the initial determination, vet all those issues. If there is some non-quantitative issue, bring it up. But they should resolve it in a way that makes it clear what the stakes are for bringing up that issue again in the future. So Cass Sunstein talks about break-even analysis. He says, if it's the case that you think there's some issue, like human dignity, I was talking earlier with some students about this really important issue about this federal rule regulating whether gay men can give blood in blood drives. There's a very important issue of human dignity there that also should be brought into consideration with the health calculations and the cost calculations. And so what Sunstein has said in those cases is the agency should ask itself, all right, how much money would it take to make us feel that we had broken even on this important non-monetary consideration? He says, that's a hard thing to do. You're searching your moral intuitions for a number in a way that's hard to quantify. But I think that's a useful exercise, at least for the agency, to explicitly think about those issues. So I imagine the non-quantitative issues would be vetted in the first round, and an agency couldn't blindside the parties with them in the second round. But it's not to say that I want to get rid of those non-quantitative issues, which I think are often really important.
Great. Desmond Dennis, Articles Editor on LPAR. I think I speak for the entire organization when I say thank you, Professor Wansley, for coming and presenting your article. We all thoroughly enjoyed engaging with it throughout the process. Professors Viscusi and Stack, thank you very much for offering your insight into the subject matter. Additionally, I'd like to thank Chris Harrelson, our symposium editor, for taking all of his time to organize this symposium, as well as our one coming up on Friday in DC. And if anyone happens to be in DC on this Friday, feel free to check out the topic. Thank you all for attending.